There are a few universal best practices. One is have good command of your systems and your data. Another thing is select good partners. If you're working with third parties, marketing companies, or it's data vendors, or it's case management software, make sure that they understand, if you're in mass torts, what a mass tort case is and what it looks like and what you need in order to prove that case down the line.
Welcome back to the Jon Marc podcast. We're here today with Executive Vice President of Mass Torts at Archer. This is Gary Goldberg. You may recognize Gary. He is at every one of these events. We're at National Trial Lawyers right now. I think last time I saw you was at Mass Torts Made Perfect. He's at all the events, and Archer is involved in the background on a lot of the things that happen with Mass Torts, and that all basically runs through Gary. So thank you very much for joining us today. We're going to talk a lot about the way mass torts work on the back end, because usually we're talking about it on the front end.
Hey, it's Mark. Before we dive into this episode, we just want to say that we built RR Digital around one simple idea. Law firms do not need more random marketing activity. They need more signed cases. That's why we handle everything from advertising to social media with a founder-led approach that keeps the strategy tight and the work accountable to a real outcome. Stop chasing vanity metrics and get more cases. Go to rrdigitalmedia.com for more information. Let's get back to the episode. We work on the exact opposite end of the business that we work. We're on the front end on the lead and case generation side. You're on the exact opposite end of what happens after a case settles, money gets distributed, and how it gets to the end client.
Yeah, why everybody's doing this in the first place.
Yeah.
Right?
Yes. We deal with many law firms. They're involved in personal injury, mass torts. A big pain point for law firms is dealing with the client expectations of, hey, I heard there was this settlement. I mean, there was just recently, you've got settlements all across the spectrum, which is actually great for the plaintiff space. But you can look at the JDC settlement in California, right? It hits the news, and then someone who signed up with a law firm, they're like, okay, when am I getting my money? And then the law firms have to deal with that pushback and not really having answers. In a mass tort case, what does that timeline normally look like for when a case settles until when people actually get their money? And how does Archer get involved in that process?
Yeah, going right to the heart of the matter,
Absolutely.
right?
No, we do not mess around here.
I'll give you some softballs later.
Well, first of all, thank you very much for having me on. I love the podcast, so it's really
Thank
an
you.
honor to be here and talk about something that might be a little different than some of your other guests have discussed, but ultimately is eminently important, as we mentioned. It's the way that if you are participating in a mass tort, you ultimately get compensated, and how your clients are going to get compensated, which is why we're all doing this in the first place. So managing client expectations is really one of the cardinal rules, the name of the game, right? Because let's call the average mass tort claimant does not have a very good, clear perception or conception of what a mass tort is and what the litigation process is going to look like. Maybe they've been exposed to courtroom dramas and they think that a decision is going to be made and checks are going to be cut within a half hour's time of that episode, right? Maybe they have been really well educated on what the litigation process looks like, but the ongoing communication throughout the life cycle of the mass tort doesn't keep them abreast of the developments, the twists and turns, the decisions that come down from the court that might delay things. Maybe they're not aware of all the back end things that we have to do, all the gates that we have to jump through as an administrator to ultimately put money in their pocket or not. And so unlike a typical maybe car wreck case or other single event personal injury case, where it tends to be somewhat linear and the facts of that case can lead to a reasonably good projection of what that outcome is going to be, mass torts have all of these different variables that play in. And then when you lay on top of that, the idea that sometimes there are bellwether trials, right? Which are a small, tiny sampling of the overall claimant population in a mass tort, but may make huge headlines. This particular claimant got a $200 million verdict. There was a $1 billion puny here. There's all this stuff that makes headlines. And mass tort claimants say, well, I want one of those, not realizing how it really works.
Well, not even necessarily knowing that they're part of a mass tort.
Yeah.
Right? I signed up my Ozempic claim, and Ozempic is actually a part of this bigger a consolidated litigation that has many other people who are in the same boat as you are, who are hoping for the same outcome as everybody else is. And it's the expectation managing when, again, on our side of this, like a claimant or potential claimant is responding to an ad, or they're, doing a search and one of our clients are coming up, and like connecting that all the way through to like the end state, knowing all of the work that goes on in between you can't expect them to truly understand it.
Well, and even the most educated and seasoned people who work in and around mass torts have a hard time handicapping and forecasting these things anyways, right? You talk to litigation funders, they can't adequately, in many cases, if you ask them, and this is just my opinion, not that of Archer, always accurately forecast the duration risk of their collateral, because maybe we're going to get a certain court decision that pushes things out. Things go on delay. There's all these variables. So those sort of macro issues are really hard to understand for an injured person who is going through something traumatic. It's the biggest thing going on in their lives possibly at that point in time. And they will passionately believe that they have an excellent case that deserves compensation, but they're tied to this bigger ship that's moving through the ocean.
So during this process, Archer is the administrator of the settlement funds and the distribution, correct?
Right.
So are you a client of the law firms? Are you a client of the clients? Are you a client of the court? How does that work?
That's a great question. Ultimately, Archer acts as a neutral in the process, right? Our job is to deal with facts, deal with the parameters established by a master settlement agreement, deal within the bounds of the various statutes governing liens and third-party recoveries from whether it's bankruptcy trustees, health insurance collectors, government agencies, and so forth. So we have this big lattice of rules that we as an administrator have to go through and check the box one by one until money can actually go out the door and to attorneys and injured folks alike. So every project is unique. We try our best really to standardize our offerings and try to create uniformity across all these programs, but they truly are all unique, from the underlying injuries to the individual litigation dynamics to the terms in these master settlement agreements, not to mention the evolution that can happen just within the industry and with other third parties we deal with from mass tort to mass tort, which can be months or years for certain classifications of torts. So it's constantly evolving, and that's why we as an organization are working very hard to create as much predictability and transparency in the process as possible. And we've come a long way in doing that. But frankly, there are a lot of things that are out of our control. But ultimately, we are a neutral party. I would say more often than not, it is the plaintiff's executive or plaintiff's steering committee who will make a decision about who the third-party vendor or vendors will be in the administration context. But it's got to often be signed off on by the defense, especially if the defense is contributing to paying for that administration. A lot of times the courts have to be involved and approve you. Sometimes there's a special master involved, but that's generally speaking the dynamic we're dealing with.
We'll talk about the plaintiff side more, because that's what we know much more about. When you're working with plaintiff firms and you have multiple firms that are involved in the acquisition process. So many times you'll have a firm that generates a case and they refer it to the handling firm. Sometimes it goes through another jump along the way. What is your involvement with those different stakeholders, or is it just with one?
Staying focused for a second on the claims administration, post-settlement administration role, I think it's helpful for those that don't understand all the way that mass torts can settle or resolve, to understand that they generally come in three flavors, right? One is what we call a global settlement. That is where a defendant says, you know what? We're waving the white flag, we're out, and we're going to settle with all firms, anybody who's got a filed case or told case or whatever, we want out of this in its entirety. And those settlements can take on a few different forms. There could be a fund established where they say, okay, we're going to put X amount of dollars aside, and if cases meet a certain criteria, okay, they're going to get paid out of this pot of money. We've seen instances, for example, let's look at the NFL concussion settlement, right? Which is a different structure. It says we're globally resolving all these cases, but we're going to establish sort of an uncapped fund with qualification criteria if you want to apply and get money from the fund. We've seen other different hybrid arrangements. We've seen, particularly with chronic disease cases, situations where defendants will say, okay, we're going to pay some for now, and we're also going to set aside some money for future injuries and other claimants that might come out of the woodwork as, their diseases metastasize and become evident, right? So a global settlement, broadly speaking, takes out all the cases.
Yep.
Then you could have individual case or firm inventory settlements or docket settlements where one law firm settles directly with the defendant for all of their mass tort cases, and it doesn't necessarily affect anybody else. And then there's sort of a hybrid arrangement, which we call a consortium, where it's a group of law firms that come together and they say, well, what about our cases? We believe that these are right for settling for any number of different reasons. We've got a group of law firms, let's settle these cases. So and Jon, this is getting back to your original question, our involvement with the stakeholders depends a lot on the form of the settlement. Because in a global settlement, we really might only be dealing directly with the executive committee or steering committee decision makers on behalf of the whole global, but we have to communicate with the individual law firms that have cases, even if they're not in a decision-making capacity on who's doing the administration.
Mm-hmm. Got it. You're this wizard behind the curtain that handles a lot of the things that people don't know about go on during the process. Can you talk a little bit about what actually has to happen after a case winds up resolving to kind of get through that marathon that has to start only when the case actually winds up getting to a point of a global settlement?
Say there's a global settlement. What is that actual, educate us, because I have no idea.
Yeah, I'll try to give you a pretty straightforward sort of base case that captures the most common situations, right? So let's say there's a global settlement. A lot of times the global settlements will be in agreement in principle. There might be some sort of MOU, some sort of term sheet, but the exact specifications of the master settlement agreement are not yet decided. That's a process that can take several months as it gets fully papered up.
They've settled,
right,
but not have a contract, the full
right. It's like a term sheet.
Yeah,
it's a term sheet. And so when we talk about managing client expectations, again, the headline says this big settlement's reached, and immediately injured folks are saying, well, where's my check? Well, the deal is not done yet, right? It's been announced, but there are particulars to work out. So that may take a few months. And then let's say in the course of normal events, we're appointed in this scenario as claims administrator, lien resolution, qualified settlement fund administrator for the sake of simplicity. There will be a process of gathering information. Maybe the information on claimants is already in a database somewhere. Maybe it needs to be collected from all the firms. But at some point, we have to get our hands on claimant data to do our jobs. A lot of times we'll work in conjunction with a special master, a third-party neutral who's going to decide how are these funds going to be split up? We have a pot of money in a global settlement fund. How much of that is going to go to this injury and this injury and this injury, or this injury category and these other categories? Or how much is going to be set aside for enhanced injuries, right? So truly catastrophic situations versus sort of the normal base case.
This is I think commonly referred to the settlement matrix.
Settlement matrix is a great example of it. You can think of it as a grid, right? And there's a lot of different ways to design these grids, but if you meet certain criteria on the x-axis and a certain on the y, that's how much you may be awarded. So this process alone can also take a few additional months. And we are in an interesting position when it comes to lien resolution, which lien resolution is the bane of a lot of people's existence, right? Because it means a third party is taking part of the settlement, but it also represents an additional time lag that we've got to manage. So the demographics of the case may dictate which agencies we have to deal with the most. You have an older population. Medicare could have hundreds of millions or billions of dollars of recovery rights in that case. And so we've got to go work out deals with them, the 50 state Medicaid agencies, every health plan in America, the military plans, so on and so forth. So all these things are sort of happening simultaneously, and it's a big dance. Who's going to qualify? What is the criteria under the master settlement agreement for who qualifies? Who's making those decisions? What are the terms of the MSA say? How much are people actually getting so we can tell collectors how much they're getting? And then we can start the process of actually negotiating and finalizing all these liens. And then you have other issues that pop up, like probate. Some of the mass torts we're dealing with right now, they've been going on for so long.
People are dead.
People are dying. So a good tip from a just practice management standpoint is making sure as your clients are getting older, they might pass away, that you know who their representatives are, you know if they have a will, because a lot of money can get stuck in probate. And we can all think of big mass torts out there right now that have ultimately older populations, serious chronic diseases, high rates of deceased individuals. And then you have bankruptcies, right? And a lot of people can't work. They've been very sick. We see a high rate of bankruptcies within mass torts. Those issues have to be worked out because a lot of times the bankruptcy trustees will make a claim against the settlement as well. So it's all this stuff, right? That if you're a mass tort claimant, you see the headline, you don't know all this is going on behind the scenes.
A mass tort can have between 5,000 and 300,000 people as part of it.
Right. Tons of people. How has your world been impacted by the growth in fraud in the mass tort space? It's been obviously a hot topic, right, for the past couple of years.
Yeah, so it's an interesting question because ultimately when cases get to the point that we're in this post-settlement context, right, and we're looking at who's going to get paid and how much, there more often than not has been a significant amount of vetting done through various channels, various methods, whether it could be a lone pine order from the court that says you have to prove up certain metrics, certain characteristics of your case before they can even advance to a certain point. A lot of times the defendants will have their counsel or the counselor will have a vendor involved in also vetting cases, right? Using technology and research tools and databases and so forth to see, okay, are these real living individuals? We need certain proof before they can move on to another stage in the process. So we need to see the medical records. We need to see clear evidence of damages, and these have to be, we need to have a fulsome set of data before anybody can get paid. So one of our jobs on the back end, and I think it's sort of inherent in all the data we're already collecting, is, we've got to have a name and a social security number and an address and all the sort of requisite pieces of information across the board. And then we do data scrubbing. We do things to verify the case. And then you have supporting pieces of information. So by the time it gets downstream to us, or ultimately when we're making payments, there's a very robust process with a lot of gates that one would have to overcome. So I think this is just my opinion, it may be a bit more of a quote unquote front end issue than when it gets to us.
It's already been fleshed out by then, hopefully.
Are you seeing any extra costs come into the process that you guys have to account for because of that extra vetting?
I would imagine that the additional scrutiny that a lot of firms are putting on verifying veracity of cases may come with an expense load for them. I think where we are seeing a little pressure on the expense side is the sheer volume that we are now seeing in mass torts due to, the expertise in marketing, giving people more access to the justice system, means that we're dealing with a lot more data. And it doesn't always mean that we're dealing with more money being paid from the defendants, right? So we have an increased burden in trying to negotiate a $100,000 lien against a $30,000 settlement, right? We've got additional scrutiny on us to make sure that people reach certain award categories. So you may see more appeals filed in certain cases that slow up the process, right? So that's where some of the additional pressure comes in on us. And fortunately, Archer is in a tremendous position to continue to make very heavy investments in technology and data tools. And we've done some amazing things over the last couple of years to be able to scale to accommodate these mass torts. But sure, it comes with an expense for sure.
So if everything runs as planned, if there's a settlement, from the time that is reached, what is the average time range for payments to start paying out to claimants?
Yeah, so let's just talk about, let's say it's a pharmaceutical or a medical device case, right, where we do expect there to be a lien of some sort for most individuals, right, because they sought some sort of medical treatment, someone paid for it. Usually you would see some sort of payment to a holdback, right? So if for every dollar of gross settlement award, the lawyers are getting a certain percentage. And then we, as an administrator, given all the cases that we've worked on, can make reasonable guesses on how much we can conservatively hold back from someone's award to take care of all these contingent issues like liens and so forth. So if someone's going to get a holdback, they may get a holdback post allocation in, let's call it 6 to 9 months, right? We talked about some of those precursor things, the things that need to happen before we can even get to that point. Are the allocations done? Does everyone have their data organized? Are there any other parties involved in this administration picture? But I'd say that that's a reasonably good estimate, is from the date of settlement to the date of some money moving out to holdback. That's a conservative number. And then the final payments out to individuals really depends on who do they owe money? What third-party lien holders are we negotiating with? If you find someone has a VA lien, dealing with the VA is arduous. It takes a long time. They're maybe not as organized, and just by nature of their structure, each individual VA facility keeps their own records. It's not like going to one central source. Or you have certain state agencies that take a long time to respond. So you could look at a situation where two people with the same injuries, just by virtue of what healthcare they received or where they lived, could have a pretty big delta in when they're going to get their money. I'd say, though, that 90% of funds are generally cleared and distributed within a 10 to 14 month time frame. But there are some straggler situations, some outlier situations that really become the long poles in the tent.
So based on that process, what can law firms do when they're generating cases, when they're filing cases on the front end to help speed up that process and make it easier for Archer on the back end and ultimately for their clients getting paid faster?
Yeah, I think there are a few universal best practices, and one is have good command of your systems and your data. When you're going to be asked to respond to a court order, maybe for a plaintiff fact sheet or a claims form or some sort of demand that the defense makes, firms that actually know their data, can navigate it, can, in an organized and efficient manner, reach out to their clients and get answers if they can't get it out of their own system, will generally have a leg up in the overall process, because sometimes these demands for additional proof or data will come towards the end of the process, right? Closer to when we're getting involved. And in some of these settlement programs, it's like a first in, first out type of situation. So if it's taking you a very long time to gather the requisite information, you're going to be at the back of the line, and there could be a lot of people ahead of you. So that's something that I think is eminently important, is have good command of your data, know how to use it, make sure it's exportable, it's actually usable, it's searchable. Another thing is select good partners, right? If you're working with third parties, whether it's marketing companies or it's data vendors or whoever it is, or it's case management software, make sure that they understand, if you're in mass torts, what a mass tort case is and what it looks like and what you need in order to prove that case down the line. Put them through that vetting, that rigorous vetting. Another thing is understand the process. Don't stick your head in the sand. When communications come out from leadership or they come out from Archer as an administrator, we do a lot of things to try to educate firms of all shapes and sizes on what's going on in the litigation, what's going on in the administration process. We have a portal. Use those tools that are available, because ultimately the firms that communicate the best with their clients, that understand the nuances and the individual circumstances of their cases, will be the ones that don't get inundated with phone calls it can be very stressful if your clients have not been educated along the way on how all this works.
A firm that we work with that does both mass torts and does PI, right? And we see that a lot, right? PI sort of transition into mass torts, but in the PI world, it's very, very local focused, right? They get their clients from their local market. Their reviews are very, very important to them because it helps them rank locally. And this firm was struggling with their reviews because they would have mass tort claimants who are waiting on a payout from an announced settlement, leaving review after review, bad reviews, waiting for updates on their cases. When is my payout coming? I signed up with your firm 3 years ago. What's going on? This is not just let me dip my toe into mass torts if I'm a personal injury lawyer, right? It's a very dangerous game because the secondary effects of doing it incorrectly, whether it's, treating it like you're gambling and just, and putting money on something and hoping for the best without having a good handling firm or good knowledge of the litigation, or not understanding that you actually have to manage these cases after you sign them up. And there will be potentially negative impact on your firm's reputation if you don't actually manage that process correctly.
You are doing the marketing. You're handing off to a handling firm. You're signing up that client to your firm, and you're creating a client-attorney relationship for the next 3 to 10 years.
Yeah. Well, even the handling firms too. It's
No doubt.
It's a big issue, especially in like the higher volume mass torts over the years, right? The Camp Lejeunes, the 3Ms, there were so many claimants that you have to manage, and if you weren't adequately prepared to handle that kind of
Was
volume,
at 300,000.
That's right.
Insane.
And mass tort firms never, mass tort lawyers generally don't have an arm's length relationship with those clients, right? Just because of the nature of it, because you can sign up cases from anywhere in the country that may ultimately retain your law firm. And unless you're, unless their case is slated for trial or you're taking depositions on their individual case, you don't have that normal sense of privity in the relationship, and they have your cell phone and all those sorts of things. I know it's been a focus for mass tort firms to create a more personalized experience, but it has to be centered around facts and good information. Because ultimately, when someone's delivering a bad review, it's probably because they didn't understand how a mass tort might work or why it takes so long. And I don't understand these words that are being used. And
what is a mass tort?
What is it? Yeah.
It's funny. One of my best friend, he signed up as part of the PFAS mass tort. He matched the injury pattern and everything. He signed up. He qualified, and he was like, "Dude, that was really intense. Like getting qualified." He's like, "What happens next?" And I was like, "You sit there and you do nothing until someone tells you otherwise." He's like, "For how long?" I go, "Forever."
Until someone tells you that it's moving.
And then I just give him, whenever I hear updates, I just tell him what's going on. He's like, "Okay, good. No, I haven't heard anything." So I'm like, if you haven't heard anything, that's good news. They'll tell you when they kick you out.
And everyone is confident they have the best case possible, right?
Yes. That's a problem, not just for the claimants, but for the law firms.
Yeah.
They don't understand what the progress is in a case, because for them, sometimes it was just like a financial investment in a certain case type. And yes, we're talking about money and this is a business, but at the same time, you're dealing with real people with real issues, and an operation at your firm that has to be able to handle the ramifications of you managing all of these clients at scale. It's a huge undertaking. I'm not trying to scare anyone to not enter mass torts. It could be great, but you have to know what you're doing.
And like learning any new line of business or learning a new skill, seeking out some mentors, some people who have been through this, the thick and the thin, the good and the bad, who've kind of seen a little bit of everything. I mean, there's a reason why mass tort conferences exist. There's an exchange of ideas there, and there are some war stories there. So there is a wealth of knowledge out there from people who have been doing mass torts for a long time. We've sort of seen it all at this point. I would not be bashful about asking for guidance and advice. And if you're vetting, either referral or co-counsel partners, really educating yourself as part of that process and who might be best positioned to partner with in any aspect of the business, because you can't simply replicate your PI model into a mass tort.
Not at all. I mean, this is one of the reasons why every week, Joe Fantini and Mark and I, we sit down and for 10 minutes, we literally just talk about what has happened in each case over the past week. It's hard for us who are in the industry to keep up on what's going on and to know like how many bellwethers are going on right now and like which trials are starting today and where are we at in the settlement process for all these different cases, let alone the ones that haven't even been consolidated yet or are just getting consolidated. It's a lot. It's a lot to consume. And we are in the industry. I can't even imagine what it's like for a claimant who's sitting on the other end and just like waiting, right? They sign up and they just wait. And we've got, talc finally moving now, right? Here we are a decade later, and there's some people who've just been sitting there with their claim for years and years and years.
Are you seeing right now more of your clients getting curious in mass torts, or they want more on the cynical side of things? Like generally, where do people stand?
I would say people are definitely, I think, bearish coming out of that, turning a little bullish coming into this year. I think there's a lot of frustration. I think there's a lot of things that have been dragging on. People are a little less excited about maybe taking some extra cash into the year, investing in that, diversifying the portfolio. I think it's changing a little bit this year on certain things where they see newer mass torts where they really like the cases better. We have mass tort clients who are
Just mass torts.
Yeah. And we have a ton of single event personal injury that some of them do mass torts, but most of them do not.
I think that it's evolved. So in the way that people had previously thought about mass torts and medical devices and dangerous drugs, that is less and less common, right? You even look at the ones that are maturing right now, right? Roundup and Paraquat, those are pesticides, environmental, PFAS, environmental. You've got all of the platforms right now that are making, the technology platforms that are like becoming mass torts, sort of a new avenue. I think like that new blood is, and seeing some of these cases actually like Snapchat settle out last week to not go to trial. You're going to see big news this week or in the coming weeks if Zuckerberg actually winds up having to sit and get examined by Mark Lanier. Like, granted, there's no cameras in the courtroom, but like that is going to be news, right? And video game addiction and Roblox, right? Things that are more in like the common news cycle. It just in conversation, like the norm versus like some obscure drug that someone took. Even Ozempic, like that's a good one because the drug is like so common and is just a trendy thing. So I think that there's, to Mark, your point, like it's on the upswing, but people are dealing with like the fallout from like the Zantacs and like all the cases that people put a lot of money in that felt the same. Tylenol.
Amplitude.
Yep.
There's still a lot of trauma from that one.
Well, one of the common threads among a lot of the litigations you just mentioned is the injury in many of them is some sort of, chronic, ongoing, latent disease, right? This is not an acute medical device failure, right? Where there's some sort of breakage, there's some sort of like immediate perforation. You're talking about claims that sort of mature over a longer time frame. Right? It's not a hip implant where there's, revision surgery and it gets fixed and it's like a finite thing in time. A lot of this is like general exposure to chemicals or contaminants, and the diseases are like things like cancer. It's things like Parkinson's that develop over time. So you may have clients who exhibit some signs of these things early on, then it actually develops into a Parkinson's claim. So on our side of things, right, when we're looking at how these cases get resolved, defendants will tell you they're sort of in a bind because they don't know what their total exposure is, and that's their position. But let's just look at a lien resolution scenario. If you're treating for a disease over many, many years, including the time frame that the case has kind of pushed and pushed and pushed, the treatment for those diseases gets very expensive.
Yeah.
Multiple rounds of chemo or like experimental drugs or just generally expensive treatment versus like a hip replacement. We know what that costs, right? And we know that can be measured into the overall damage argument. From a lien resolution perspective, we can figure it out. So it's creating some additional complexities for sure.
Question two from something you said earlier. So if in some of the settlements, they put money into a trust or a fund for future, claims or additional things that happen, who administers those additional funds that are set aside? Is that Archer or is that another third party that manages that money?
Yeah, sometimes we will do that. So one function that we fulfill is we do qualified settlement fund administration, which is a specific type of escrow account where we act as a trustee of funds to make the distribution. But we can also do that in the capacity of saying, okay, we're going to be the trustee for this pot of money. And as people make additional claims down the line and those claims are ultimately proven, we can make distributions out of that, subject to the rules and the oversight that we have as trustee of those funds.
Got it. What else do we need to know about this process that we haven't asked?
Yeah,
I would favorite interview question. I love asking people that. Not in podcasts, by the way. When we're interviewing people to hire, I always ask them. I say, "What is the one question we have not asked you that you would like to answer for us?"
if we boil all this down, right, and get to the heart of the matter, clients really have one question: when are my clients going to see their money? Right. That's kind of how we started this whole conversation. And Archer is in an interesting position because we are this gatekeeper, right? That looks like this monolith between someone's settlements.
Gary, I want my money and I want it
coming
now.
out, right? And what I would tell everybody is that even though the landscape has become more challenging, these macro issues are more challenging, we are working very, very hard. It could be its own episode unto itself on using all sorts of technology, processes, people, all these improvements to try to give a better and more efficient experience to everybody, even given these kind of staggering complexities of some of these issues. So if you're looking at the post-settlement process now versus where it would have been on an apples to apples basis 3, 4, 5 years ago, we are leaps and bounds better as an industry and as an organization, because we've learned through a lot of analysis, a lot of trial and error, through empirical experience, and now we have technologies that have really assisted us. Nobody builds tech for our industry, right? It's like too niche, right? But now we have some really cool tools to improve the overall experience and hopefully, get money into injured people's pockets faster. So we're trying really hard, guys. We're working very, very hard on it.
Yeah, I appreciate you coming on the show, and we don't do educational episodes. Like, we usually are like sharing strategies and tactics, like things people can implement. But this is important stuff for, I think, our audience to know and learn and understand what happens in the background. Yeah, the mass tort world is robust in its nuances and the different vendors that you have to interact with and the players and the landscape. And
yeah, it's not as simple as settling a case and the insurance company sending you a check.
Yeah, we wish it was that easy, but it is not. So thank you so much, Gary, for joining us.
If people have questions after watching this episode, which they will, how do they get a hold of you?
LinkedIn, you can email me, ggoldberg@archersystems.com. You can find me at one of these conferences. You can go to archersystems.com and make an inquiry through the website. I generally give my cell phone out. We'll maybe not do it on a recorded podcast, but I'm pretty accessible, and we've got social channels and all that stuff. And I have other colleagues who are wonderful and experienced and knowledgeable. So if you run into someone from Archer, don't be scared. We're generally pretty nice folks, and hopefully can help you out.
Dude, fantastic episode. Thank you so much for coming on. We absolutely loved it.
Thanks, everybody, for watching. If you like this episode, please click subscribe. We're on YouTube. We're on LinkedIn. Follow us on Instagram. And we will see you on the next episode of the Jon Marc Podcast.